Subcommittee will come to order without objection. The chair will be authorized to declare recesses during votes today. This hearing is the second in the series on the Electronic Communications Privacy Act, otherwise known as ECPA. Today we will examine the issue of geolocation and its use by law enforcement in criminal investigations. While this hearing was planned before the attack in Boston, those tragic events highlight the importance of the topic. The stakes are high, as in any ECPA reform. Congress needs to strike the right balance to protect privacy rights without undermining law enforcement. The term geolocation is often used broadly and in a variety of contexts. Geolocation refers to the method of assessing the location of an electronic device, typically a cell phone, but sometimes a vehicle, with or without a tracker or a computer. Geolocation is often related to the acquisition of cell tower information to determine the general location of a cell phone. Less frequently, geolocation is related to the use of global positioning systems, or GPS. The results from its use often vary, depending upon the type of cell phone being tracked or the provider on whose network it operates. The information about a phone's location can vary from a city block to specific latitude and longitude coordinates. The primary objective of this hearing is to examine whether the electronic acquisition of a device's geographical location is covered by the Fourth Amendment, and if so, what level of legal process should be required before accessing such information. The hearing will also examine how law enforcement makes use of this information and its importance in their response to criminal and national security threats. ECPA has not kept pace with the assortment of new communication devices and other technologies that are now widely available in today's marketplace. This is particularly true with geolocation technology. As GPS technology has become cheaper, more widely available, and used more frequently in our daily lives, the legal authorities and restrictions that are or should be in place to govern when and where such information is accessed and used have become less clear. No one doubts that geolocation information is useful, especially to law enforcement officers and agents. The larger question is, how do we balance the needs of law enforcement with the expectations of privacy of those they are charged with protecting? In U.S. v. Jones, the Supreme Court proposed that new intrusions on privacy may spur the enactment of legislation to protect against these intrusions, as had occurred in the case of wiretapping many years ago. The Court asserted that Congress should enact a comprehensive statute regulating the use of GPS tracking technology for law enforcement purposes. Since all geolocation capabilities are not created equal, our task in enacting comprehensive legislation is more complex. Unfortunately, Jones was limited to the installation of a GPS tracker on a suspect's vehicle and gives us limited guidance. I am dismayed to point out that the Department of Justice declined to testify at today's hearing. I was tempted to have an empty chair for their witness should they change their mind at the last minute. There is not an empty chair at the witness table, but the chair notes that there are plenty of empty chairs in the room should they decide to appear. As the nation's most frequent user of ECPA for geolocation purposes, the Department is in a unique position to educate the members of this subcommittee on the status of federal law and the Department's current practices in seeking court orders for geolocation information. While DOJ has briefed committee staff on ECPA and geolocation, the Obama administration has refused our request to testify in public because it lacks a clear policy position on how best to reform ECPA. This is unacceptable, and I don't want to spend a lot of time working on something that is workable when all of a sudden, out of the blue, there will be a statement of administration policy that will threaten a veto over hours of work and input from everybody except the Department of Justice. We must unfortunately move forward in their absence. I welcome our witnesses who are with us today and look forward to their testimony. I'm now recognize the gentleman from Virginia, Mr. Scott, the ranking member.
Thank you, Mr. Chairman. Mr. Chairman, today we meet to discuss issues related to geolocation, privacy, and surveillance, and the need to clarify the standards of government access to certain types of personal location information. Technology affords us greater conveniences, but advances in technology present new challenges to our privacy rights. Much more information is generated about us, and we're presented with questions about how it is stored and by whom it may be accessed. Supreme Court 1967 decision, Katz v. United States, continues to direct our privacy jurisprudence. In that case, a man's calls from a public payphone booth were recorded by a device attached to the outside of the booth by the FBI. The court ruled that this eavesdropping was a search under the Fourth Amendment because it violated a man's, quote, reasonable expectation of privacy. That standard should continue to guide us today. When we go somewhere in public, we know that we may be seen by others, and even if we do not want others to know where we are, the visual recognition by others is a risk we take. What we do not expect is that our carrying of a personal communication device, such as a cell phone, will be used by government to track and record our every move. This is particularly the case as cell site location information has become, in many cases, as accurate as GPS because of the growing number of cell sites and the use of microcells that cover extremely small areas. We have laws that make accommodations between privacy rights and sometimes urgent need of law enforcement to investigate crimes, and that's why Congress drafted federal statutes to restrict government access to the content of electronic communications, but provides a less stringent standard for accessing non-content records reflecting just that a communication took place, but not the content of the communication. The Electronic Communications Privacy Act, which was enacted in 1986, was forward-looking in some ways, but did not contemplate every possible technological advance. Because the statute did not foresee the current state of location technology, the law does not provide clear guidance as to what steps the government must take in order to obtain location data from devices like cell phones and navigation systems in cars. While we should have exceptions for emergency situations and situations where there may be a need to locate a missing person, we need legislation to address the lack of clarity in the law by generally requiring the government to show something possibly probable cause to get a warrant in order to obtain historical and prospective data location about our citizens. Given our expectation of privacy, this should be the starting point for our discussion of the issue today. I'll yield back the balance of my time.
I thank the ranking member. The chair now recognizes the most recent chairman emeritus of the committee, the gentleman from Michigan, Mr. Conyers, for his opening remarks.
Thank you, Chairman Sensenbrenner and Ranking Member Scott. I'll put my statement in the record and indicate my support and co-sponsorship of H.R. 1312 and warmly welcome the witnesses that are joining us here today. This question of cell phones and tracking locations are right smack up against the privacy considerations, and this discussion and this legislation will be very important in that direction. And so I am happy to join all of you at this hearing, and I return the balance of my time.
I thank the distinguished chairman emeritus. By tradition, we swear witnesses in at the beginning of each hearing. So will the witnesses please rise, raise your right hand. Do you and each of you solemnly swear that the testimony you will give before this committee shall be the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that each of the witnesses answered in the affirmative, and the chair will now introduce the witnesses. Mr. Mark Eckenweiler is senior counsel with the firm Perkins Coy. His focus is in electronic privacy law, civil and criminal liability for online conduct, computer intrusions, and service provider interactions with law enforcement. Mr. Eckenweiler previously served with the Department of Justice as a primary authority on federal electronic surveillance law, including the Wiretap Act, the Pen Register Trap and Trace Statute, the Electronic Communications Privacy Act of 1986, and CALEA. Most recently, he was the Associate Director for Technology with the Office of Enforcement Operations in the Justice Department's Criminal Division, where he oversaw all federal applications for Internet communications surveillance orders. He received his Bachelor's of Arts degree from Harvard, his Master of Arts from Boston University, and his law degree from NYU School of Law. Mr. Peter Amatafieri has been a detective with the Rockland County District Attorney's Office for over 40 years, in the last 25 years as Chief of Detectives. Since 1990, Mr. Amatafieri has chaired the Investigative Operations Committee for the International Association of Chiefs of Police. He is a member of the Criminal Intelligence Coordinating Council and served as a regional expert for the Office of National Drug Control Policy Technology Transfer Program and consulted with the Foreign Terrorism Tracking Task Force, which was established in 2001. Mr. Amatafieri is a graduate of the FBI National Academy, holds a BA from Siena College and a Master of Arts in Criminal Justice, and has concluded the coursework in the doctoral program at the City University of New York. In 1992, he was awarded a Fulbright Fellowship for graduate study in the United Kingdom. Ms. Catherine Crump currently serves as a staff attorney for the American Civil Liberties Union Speech Privacy and Technology Project. She is currently litigating constitutional challenges to cell phone tracking by law enforcement and is seeking information related to the Justice Department interpretation of how United States versus Jones applies to its location tracking activity. If you find that out, please let us know, because apparently they don't want to tell us directly. She has directed nationwide requests for public records regarding law enforcement's use of cell phone information and license plate readers. She received her Bachelor of Arts from Stanford University and her law degree from Stanford Law School. Mr. Matthew Blaze is Associate Professor of Computer and Information Science at the University of Pennsylvania. Mr. Blaze's research focuses on cryptography and its applications, trust management, human scale security, secure systems design, networking, and distributed computing. His focus is in security technology with bearing on public policy issues, including cryptology policy, wiretapping, and surveillance. He received his Bachelor of Science degree from City University of New York, Hunter College, his Master of Science degree from Columbia, and his Masters of Art and PhD from Princeton. Each of the witnesses' written statements will be entered into the record in its entirety, and I ask that each summarize his or her testimony in 5 minutes. We have the lights there. The yellow light means you should speed up, and the red light means you should stop. Mr. Eckenweiler.
Chairman Sensenbrenner, Ranking Member Scott, Mr. Chairman Emeritus, and distinguished members of the subcommittee. Thank you for your invitation to testify this morning on the important topic of cell phone location privacy. My name is Mark Eckenweiler, and I should state at the outset that my comments today reflect only my personal views. I will, of course, be drawing on my 16 years of experience working on a daily basis with the Electronic Communications Privacy Act, or ECPA. I am not speaking today on behalf of the Justice Department or my current employer or any individual client. My testimony today focuses on both the types of location data that law enforcement seeks from wireless providers and the legal rules that restrict such disclosures. I have 3 main points. First, not all location data is the same. It can be generated in a variety of ways, and one type of location data, cell site location information, is less precise than others. Second, In general, existing law provides a carefully calibrated set of meaningful protections for wireless user location data. The sky is not falling. And third, the current framework does, however, have some gaps and inconsistencies that I think would benefit from careful study by this committee. Now, I mentioned that there are different types of location data. Cell site information is generated in the ordinary course of business whenever a user sends or receives a phone call or a text message. It does not provide pinpoint location information for a phone. Rather, these records indicate which cell tower handled a particular communication. Because tower spacing varies widely across a range of locations from rural to suburban to urban settings, so does the area covered by each tower, and as a result, cell site location information may place a phone on a given city block, or it may only indicate a very large area of several square miles in which a phone was apparently located at the time of a communication. Contrast this with precise location information. This separate class of data, which includes but is not limited to GPS, is different not only in its level of precision and thus its privacy invasiveness, but also how it is obtained. One significant difference is that precise location information may be generated even when the phone is not in active use, sending or receiving a communication. Existing law treats these two types of information, cell site and precise location information, very differently. Under ECPA, law enforcement can obtain stored cell site records, that is, for some period in the past, only by applying to a court for a so-called 2703D order. Now, the standard for issuance of this, specific and articulable facts, is an important safeguard, and indeed, the executive director of the Electronic Frontier Foundation testified before a joint House-Senate committee that this standard affords, quote, a high degree of protection, unquote. The rules governing prospective collection of cell site information, that is, real-time collection, are a subject of profound disagreement among the federal courts. Some of them apply this same 2703D standard in granting so-called hybrid orders. Others see a gap in the statute and have required a warrant because there's no other available mechanism. Because precise location information, by contrast, is not collected by wireless carriers in the ordinary course, it is not typically available as a stored record for past periods. For ongoing surveillance, ECPA provides no clear statutory mechanism, and as a result, the practice at the federal level has been to seek a search warrant under Criminal Rule 41, based upon a showing of probable cause. Finally, as set out in more detail in my written statement, the current legal framework is not perfect. There are a number of issues that merit this committee's attention, and I would be pleased to discuss those in greater detail during the Q&A. In summary, Mr. Chairman, existing law, especially ECPA, recognizes the important privacy interests at stake by putting meaningful legal barriers between law enforcement and users' location data. In doing so, current law takes the approach of careful calibration of legal standards rather than one size fits all. Thank you for the opportunity to appear this morning. I look forward to your questions.
Thank you, Mr. Modafferi. Could you please press the
Thank you.
voice button?
Good morning, Chairman Sensenbrenner, Ranking Member Scott, and members of the subcommittee. Thank you for this opportunity to discuss the role of geolocation information plays as evidence in criminal investigations and its importance in law enforcement's effort to seek justice and public safety in the 21st century. It is from the vantage point of being a detective for 40 years and currently Chief of Detectives and a longtime Chairman of the IACP's Police Investigative Operations Committee that I have seen a great deal of great and growing value of geolocation information to criminal investigations. Two issues have arisen over the past 10 years which have increased this value significantly: globalization and wrongful convictions. When this information is obtained in early stages of investigation, it provides fundamental building blocks on which successful cases may rest. Requiring probable cause in the initial stage of an investigation to obtain certain types of geolocation information would make it significantly more difficult to solve crimes. Investigative issues of time, technology, and process must be addressed in a way that allows us to proceed from the initial stages of an investigation, where little is known and nothing can be assumed, to point where investigators establish probable cause. The classic questions presented in investigations, who, what, where, when, why, and how, can be answered with geolocation evidence. To learn facts and make valid assumptions, investigators use available geolocation evidence as a filter to help corroborate or refute statements and conclusions at any time during an investigation, to confirm or dismiss alibi statements or claims of witnesses, and to act as for stored times and places. It can be the only witness at a crime scene. Geolocation information gives us more than the ability to solve crime. It can prevent a wrongful arrest by revealing that suspect was not at the scene of the crime. Mistaken identifications are a leading cause of wrongful convictions. It can provide us with accurate time and place evidence that can confirm or refute identifications, confessions, and inaccurate testimony. Justice and public safety in the 21st century is a new ballgame. Today's criminal investigators are more mobile than ever. That makes law enforcement access to geolocation information all the more important. Law enforcement must take advantage of geolocation information and location-based information just as the private sector does. Smartphones, mobile devices, GPS, and pre-installed technology like OnStar are available, with more location technology evolving at a rapid pace. Technologies also generate historical data and business records from which location information can be derived. ECPA, credit card, and debit transactions are examples. If we do not have standards of access in place to ensure we can get location evidence early in the case, then law enforcement will miss out on the productivity impact of advancing technology. That affects our ability to do our jobs the best we possibly can. An example that demonstrates this type of importance of geolocation information was a bank robbery case in Rockland County area. In the area around Rockland County, there were 7 bank robberies. We had no success in identifying the perpetrators of those crimes until a witness came forward. She was a victim of one of the crimes, and she was at a gas station and saw a person who she believed was one of the robbers, and she was able to take a photograph of that person's car, and it had dealer license plates on it. Using a subpoena, the detectives were able to get a possible identity of the person who purchased that car. Police then focused with a subpoena on the basic subscriber information and phone numbers. That was followed by a sole-ordered subpoena, which produced historical cell site locations. Then a trap-and-trace pen register surveillance with location authorization was established. Utilizing probable cause, we then attached a GPS device. The result was an arrest of the suspects immediately after their next robbery while they were holding the proceeds of the crime. At the beginning of the case, standard identification procedures were of little value, and there were no suspects in the case. A witness opened an avenue of investigation. To build the case, subpoenas for stored cell phone call detail records with location information were issued once we had that lead. The subpoenas produced suspects and locations that were essential to reach probable cause. Throughout the investigation, location information revealed and confirmed the activities of the true perpetrators. Not only did it help identify the right people, it resolved a misidentification and prevented a wrongful arrest. To conclude, Mr. Chairman, geolocation information has become an essential building material in the construction of many criminal investigations. It can be the concrete that cements eyewitness identification, the criminal, and the crime scene together. To gather and integrate this information in the initial stages of an investigation, we must have a reasonable balance between the standards of access required to obtain location evidence and the need of the investigation to proceed. Just as important, law enforcement must be able to receive these facts in a rapid and complete response from the holder of the information record. Requiring probable cause to get basic limited information about a person's historical location could make it significantly more difficult for us in law enforcement to solve crimes and seek justice. Thank you.
Thank you, Ms. Crump.
Good morning, Chairman Sensenbrenner, Ranking Member Scott, Chairman Emeritus, and members of the subcommittee. Thank you for the opportunity to testify on behalf of the American Civil Liberties Union. Over the past week and a half, our nation has been gripped by the horrific events in Boston. Today, our thoughts remain with the victims of that tragedy and with their families. Although details of the investigation are still unfolding, it is apparent that electronic surveillance played an important role in locating and tracking the suspected perpetrators. That is as it should be. No one denies that electronic surveillance can be an important tool for law enforcement, and indeed, in horrific and rare events such as what transpired in Boston, an essential one. That is why the ACLU has always supported an exemption in the law permitting immediate disclosure of location data in aid to agencies in such life and death situations. However, in routine investigations, law enforcement agencies such as the local police and the FBI should secure a warrant based upon probable cause to obtain mobile phone location data. The ACLU supports the Geolocation, Privacy, and Surveillance Act because the framework it establishes allows law enforcement agents to access the tools they need while providing an independent check and balance through review by a judge, which will ensure that innocent Americans do not have their privacy violated. Mobile phone location technology provides law enforcement agents with an invasive yet inexpensive method of tracking individuals over extended periods of time and unlimited expanses of space as they traverse both public and private areas. It also makes it possible for law enforcement agents to identify all individuals located in a particular location, a valuable tool, but one that by necessity can reveal the location of thousands or even tens of thousands of innocent Americans. In many parts of the country, the police have been tracking mobile phones for days, weeks, or even months at a time without ever having to demonstrate to an independent judge that they have a good reason to believe that tracking will turn up evidence of wrongdoing. Mobile phone location data implicates strong privacy interests because tracking people's movements makes it possible to learn a great deal of personal and private information about them. As Justice Alito explained, society's expectation has been that law enforcement agents would not, and indeed in the main could not, track people's movements over a long period of time in their car, an observation which applies with even greater force to the cell phones people carry with them all the time. The warrant and probable cause requirements are essential components of the Fourth Amendment. The probable cause requirement is not high. Law enforcement merely has to have a good reason to believe that a search will turn up evidence of wrongdoing. It is useful to identify points of agreement between law enforcement interests and those civil society organizations concerned about privacy. First, the Department of Justice already recommends that its agents obtain a warrant based upon probable cause to secure real-time precision location information, the very standard that the ACLU supports. Also, local law enforcement agencies such as the County of Hawaii, Wichita, and Lexington, Kentucky already secure warrants across the board. Thus, merely codifying a long-standing Department of Justice policy would help protect Americans' privacy. Second, we agree with Mr. Eckenweiler, as he stated in his written testimony, that the so-called cell tower dumps, the acquisition of location data of all individuals at a particular location, pose especially grave privacy concerns because they could sweep up the locations of thousands of innocent Americans. Like Mr. Eckenweiler, we believe the committee should consider additional statutory protections such as limits on the number of records or the length of time window requested, or protocols for sealing or destroying the documents obtained. We also agree with numerous law enforcement representatives that the current legal standards in force are unclear. However, we part ways over the applicable legal standard because the warrant and probable cause requirement should apply across the board to cell phone location data. These requirements are especially important today given the tremendous and rapid technological development over the past 10 years that make it easier than ever to track Americans' every movement. The ACLU supports passage of the GPS Act because it would ensure that law enforcement agents obtain a warrant based upon probable cause to access mobile phone location data subject to appropriate exceptions. Thank you.
Thank you, Mr. Blaze.
First of all, thank you. Thank you, Chairman Sensenbrenner and members of the subcommittee for the opportunity to testify here today. The focus of my remarks will be on the technology of mobile location tracking and the trends that we can expect mobile location technologies to follow as these devices become a more ubiquitous and critical part of our daily lives into the future. I think the most important thing for the committee to consider in drafting legislation regulating the use of location information for mobile devices is that this is a very rapidly moving area of technology enjoying continued and explosive growth. and that will continue for the foreseeable future and beyond. I'd like to talk for just a few moments about how cellular mobile devices operate. Of course, as you know, cellular telephones and cellular data devices, such as tablet computers, operate not with a wired connection, but rather with a radio connection. The radio connection is provided by a service provider that operates a network of base stations throughout its geographic coverage area. These base stations are alternatively called cell sites or cellular base stations, or sometimes towers or sector antennas. The terms are approximately equivalent for our purposes here. Unfortunately, the capacity of any given base station is limited by two fundamental factors. The first, and today less important one, is the radio range over which they can operate. A cellular telephone under ideal conditions in a clear radio spectrum may be able to operate with a base station as far as a mile or two from the cellular handset. But the more important limitation is the spectrum capacity of the frequency bands that are used by the mobile service providers. Each base station has a limited number of calls that it can process, a limited number of data services that it can handle simultaneously from different customers. So as cellular and mobile technology has grown and become so important, as we all get different mobile devices and use them more often for more things with higher bandwidth broadband connections, service providers have had no choice but to reduce the geographic area over which each base station operates, so that smaller cell towers, smaller antennas cover a smaller number of users who can take advantage of the services that they've provided. And this trend has, over the last 15 years, been continuously in the direction of higher and higher density. We have provided more spectrum to mobile service providers, but the amount of spectrum is ultimately limited not by regulation but by physics. And so really the only direction in which growth can happen at the explosive pace that it's occurring is by making the base stations serve a smaller and smaller geographic area. One of the trends is the use of small cell sites that cover very small geographic areas, such as an individual home or an individual office. These are sometimes called microcells or picocells or femtocells. Various service providers offer them. These may cover an area as small as this hearing room or our homes. Because of this increased density and because of this increased amount of usage, it's become more difficult to meaningfully distinguish between cell site location and other geolocation technologies such as vehicle-based GPS and precise location technologies that are used for E911 services, particularly if we consider how revealing this information is about our daily lives. We carry, unlike vehicle-based GPS surveillance, we carry our cellular telephones with us everywhere we go. We have them on at all times. We take advantage of data services that cause them to send and receive data without us being aware that it's occurring in many cases. And we can use them indoors and in private spaces, unlike GPS devices, which generally work only outdoors with a view to the satellite. And then finally, the precision with which these can be located is increasing as the density improves, and that trend is going to continue because service providers have no choice but to improve density if they want to provide more services.
The gentleman's time has expired.
Oh, I'm sorry, my light wasn't working.
That light isn't working, so sorry about that.
Thank you, Mr. Chairman.
Okay, the chair will enforce the 5-minute rule during the question time, and first recognizes the chair of the full committee, the gentleman from Virginia, Mr. Goodlatte.
Thank you, Chairman Sensenbrenner, and thank you for holding this hearing. I regret that I wasn't able to be here at the outset, so I'm going to use my question time to offer my observations about geolocation issues. And I'll start by saying that the Electronic Communications Privacy Act, or ECPA, provides a myriad of protections. Keep in mind that it was enacted well before our everyday use of cell phones and the internet. Yet ECPA sets forth the rules that prevent unauthorized government access to certain electronic records. Even when it became law in 1986, ECPA, perhaps unintentionally, set the standards for the court-authorized disclosure of geolocation information. A suspect's location is often only a piece of the puzzle for law enforcement, but sometimes that piece is a matter of life or death. In 2001, enhanced or E911 was deployed in the U.S. to associate a location with the origin of a phone call. Geolocation is critical in cases of child abductions, lost hikers, and missing Alzheimer's patients where every minute counts. In many other investigations, geolocation is a vital building block in order to prevent or curtail a crime. Many criminals use false identities to impede law enforcement so they may complete their crimes and commit more. In every case, the identity of the criminal is essential for the investigation to move forward. The geolocation of dangerous fugitives is crucial, particularly after they are convicted of crimes like rape and murder. Today, many civil liberty concerns center on the abundance of new technological devices and a lag in the law keeping pace with this new technology. For instance, the law is well settled when it comes to police entering a home to arrest someone or conduct a search. However, complexities arise when, by the use of cell phones, we are permitting communications providers to record our location to route a phone call. We also allow them to record our location in order to advertise to us or send us instant coupons on our cell phones when we subscribe to a certain app. Cellular providers often use cell tower data, but also use GPS technology and our public Wi-Fi connections to determine where we are. In updating our federal surveillance laws, Congress must weigh our privacy interests with the needs of law enforcement without stifling commerce and innovation. Last week, the Department of Justice briefed Judiciary staff on its current practices in seeking geolocation data. I was encouraged to learn that the Department seeks a court order for every type of geolocation information it acquires. At a minimum, the Department obtains what is called a 2703D federal court order when it seeks historical cell site data on a particular cell phone. This cell site data only provides very general location information, which can vary widely. On the other side of the spectrum, the Department of Justice obtains a search warrant from a federal judge when it seeks very accurate, real-time location information based on GPS satellite technology. Such search warrants are based on probable cause, the same standard specified in the Fourth Amendment to our Constitution. While these practices are encouraging, current DOJ practices do not carry the same weight as federal statutes. The privacy interests we have in our cell phones are being protected today through a patchwork of federal laws. Our task is to re-examine current laws and give clarity to individuals, corporations, innovators, and law enforcement. I look forward to working with my colleagues to examine geolocation privacy and surveillance. Our efforts must protect individual liberties by providing clear guidelines for when and how geolocation information can be accessed and used. And I thank Chairman Sensenbrenner and yield back.
I thank the full committee chair. The chair recognizes the ranking member, Mr. Scott of Virginia.
Thank you, Mr. Chairman. Mr. Modafferi, you talked about a crime where somebody had committed 7 robberies. Was any attempt made to get historic data at those locations to see if one person had been in all 7 sites at the particular times?
You mean a general subpoena for anybody in that area? No.
Well, if you got a tower dump from the 7 different sites and cross-referenced and found that only one person had been at all 7 sites at the same time, would that have been possible information to get?
Not logically, because all 7 robberies, the robberies were in between 3 and 6 months apart in different locations in a tri-state area.
How long is the tower information kept?
That I don't know.
Anybody know how long tower information is kept?
Ranking Member Scott, it varies according to providers. Some keep that information for a few months, some keep it for up to a year or 2.
And so if it was one of the services that kept it for a year or 2, then you could have gotten information from the 7 different locations. Is that true?
If there were, in fact, network events that would be represented, certainly when the records are available, the government can compel them. Whether or not there would be a commonality across all 7 of those locations is dependent not just on whether the phone was present, but whether there was an active communication like the sending or receipt of a text message or a phone call.
The information that you were near a site is not recorded?
When the government obtains a tower dump that you referred to, what is produced is only a set of affirmative network activities, like the receipt of a call. A phone call is answered, a phone call is placed. It does not reflect the presence of all phones that are simply on but not in active communication at that time.
Is that because the information is not available or because it wasn't, you can't get it?
It's not the practice of the carriers to log that. There is not a real technical reason to retain information at that level of granularity.
How expensive is it to the either law enforcement if they pay for it or the provider to provide a tower dump?
I'd say a tower dump is fairly burdensome for the providers to disclose to law enforcement, and in practice what often happens is law enforcement will obtain an order for a certain set of information, and there's often a negotiation, as there is in other cases, grand jury subpoenas and administrative subpoenas, to see if the scope of the request cannot be narrowed.
Ms. Crump, we were talking about probable cause before you get all of this information. Probable cause is usually that a crime has been committed, and what would be the standard after the crime has been committed to try to catch people?
Are you contemplating the fugitive type situation?
Yes.
I think that the civil liberties groups that support a probable cause requirement believe that in general the standard should be probable cause that a crime has been committed, but also agree that it's important that fugitives be apprehended and don't have an objection to cell phone location data being used in that circumstance. So a standard, for example, that there was an arrest warrant out for someone and that location information was useful to effectuate that arrest warrant is not something that anyone would object to.
There's an expectation that the government isn't following you everywhere you go. How would you deal with emergency situations?
We support an emergency exception, such as that in place in the GPS Act. Earlier, Mr. Goodlatte set out a number of examples of emergency situations, a child abduction, a lost hiker, and situations like that. I think everyone agrees that in those types of circumstances, it's important that law enforcement be able to act immediately, and that if there's not enough time to secure a warrant, that they should be able to proceed on an emergency basis and go ahead and locate someone.
Thank you, Mr. Chairman.
Thank you. The Junior Chairman Emeritus of the committee, the gentleman from Michigan, Mr. Conyers.
Well, I thank the Senior Chairman Emeritus for recognizing me. This is an unusual hearing in that I can't remember ACLU ever quoting Justice Alito before, nor can I remember all of the emeritus being on the same bill of a Republican member of the committee. And the general agreement actually among the four witnesses. The only difference of view that I've been able to note is the difference between a probable cause standard and a 2703D. And I was wondering, do you firmly hold to that to the 2703D order, Mr. Eckenweiler, or are you prepared to reluctantly go along with the probable cause standard that's in the bill?
Mr. Conyers, I think as Mr. Modafferi pointed out, one of the difficulties with adopting a probable cause standard for that less precise class of location data, cell site information, has significant potential to impair law enforcement investigations. Think of this as the building block of, it's one of the building blocks for an investigation. In some cases, it may be used in conjunction with bank records. It may be used in conjunction with telephone toll records. There are various pieces that go into an investigation, especially at those earliest stages when probable cause has not yet been developed. And so I think there would be significant costs to law enforcement if an across-the-board probable cause standard were to be adopted. But I would also refer you to the language I quoted earlier from Jerry Berman, the Executive Director of EFF, testifying before a joint House-Senate Judiciary Committee hearing, pointing out that the 2703D standard is in fact meaningful. Mr. Berman pointed out in his testimony, court order protection will make it much more difficult for law enforcement to go on fishing expeditions. And he pointed out in that same testimony that law enforcement would have to meet this particular showing, this need to establish access to these records based on specific and articulable facts. So law enforcement has to tell a story. It's not like certain other kinds of compulsory process, a grand jury subpoena, which merely issues from the prosecutor. It's not like a pen register order to monitor the non-content activity on, say, a telephone line, the numbers dialed out or in. Those kinds of orders under the existing statute simply require a certification to a judge who has no discretion. 2703 is different. A factual showing has to be made to the court, which the court may then weigh, and based upon that weighing of the showing, may grant or deny the application.
Professor Blaise, I know you have a slightly different view.
I think this is one of the areas where Mr. Eckenweiler and I disagree. The gap between these different technologies is narrowing, I think, sufficiently that we can't really make meaningful distinctions between how revealing they are. So if we understand GPS location technology to be to be revealing enough to warrant one standard, I don't see any technological basis to understand cell site location as being sufficiently less precise or less revealing to merit a different standard. The gap is narrowing in how precise they are, and in some cases, cell site location can reveal location information when vehicle-based GPS would be unable to, such as when the target is indoors.
Well, I guess the probable cause standard based on the Fourth Amendment is more compelling. But, you know, when you read these off the top, Chairman Sensenbrenner, you could probably use either one to accomplish your goal. And I thank you for the time.
I thank the gentleman from Michigan. Gentleman from Louisiana, Mr. Richmond.
Thank you, Mr. Chairman. Let me see. My first question, and I guess I'll direct this question to Ms. Crump. I'm sorry. Do cell phone users ever find out that their geolocation information has been divulged?
Thank you for the question. That highlights one of the key problems with this form of tracking. On occasion, cell phone users do learn that they are tracked, but in order for that to happen, in general, they have to be prosecuted, and then that evidence has to be used in the case in chief. That means that whenever someone is tracked and they're innocent or the government chooses not to disclose that information, individuals never learn they were subject to that technique. That has had the effect of meaning that for a long time, the government's policies and procedures for engaging in cell phone tracking have been shrouded in secrecy. And we believe that it's important that individuals who are subject to this form of surveillance receive notice, at least after the fact and the investigation is closed, because that will increase the public's awareness and information about how the government is balancing civil liberties and law enforcement interests.
Now, is that your position pretty consistent with what they do with wiretaps?
Yes, that's true.
So after a wiretap, they do disclose to the person that they were subject to a wiretap?
Yes, that's the case.
Do they also disclose that to the person who may have been on the phone with someone on a wiretap that their call was intercepted, or you all don't do that? Do you know that, Mr. Ackenweiler?
Yes. In general, the requirement under Section 2518 of Title 18 requires that notice be given. Often the court may direct the scope of the disclosure, but it is not simply limited to the person who is named in the wiretap order. So in direct response to your question, yes, other communicants with whom that person has, say, spoken on the phone would also typically receive notice.
Is there a time frame on that notice, or?
The statute, Title III, the Wiretap Act, currently says that the what's called the inventory must be given within 90 days after the termination of the wiretap, although the delay of notice may be extended for good cause shown to the issuing court.
And I don't know if we discussed it, but I'll go back to you, Ms. Crump. What standard do you think should be applied to the one-time ping, or the real-time looking at where a person is once?
Our view is that a one-time, real-time tracking ping should also require probable cause. The reason for that is you do not know, generally speaking, when you conduct that ping, whether someone is going to be in a, for instance, a private place where they have a reasonable expectation of privacy, and the better rule is a probable cause requirement across the board.
And we've mentioned a couple times about reasonable expectation of privacy, and I guess as technology evolves, at some point, do you think there's going to be a discussion that if you have your cell phone with you, you probably don't have a reasonable expectation of privacy?
No, I don't think people should have to give up their privacy rights simply because today's modern era essentially requires people to have a cell phone in order to participate. It has traditionally been the case that individuals have been able to move around public and private places without being subject to the continuous monitoring and permanent recording of their movements. I think that's an important freedom, and that it shouldn't be sacrificed just because we now have cell phones.
Well, you mentioned the recording of their movements, and I guess that one's probably a lot easier than the real-time where you are, and I wouldn't want anyone recording my movements, but do I have a reasonable expectation of privacy that if I was in the audience, no one would know I was here. I mean, as it evolves, the question is how realistic it becomes and how reasonable that expectation is. And that's why I pose it, because at some point, I think that that question will become very relative to all of the conversations that we have in terms of our privacy. Mr. Eckenweiler, did you want to add to that?
It's certainly true, Congressman Richmond, that there are different kinds of location data, many of which are overtly public. People who post on social media and choose to turn on their location disclosure feature, I think it would be abundantly clear that there's no expectation of privacy that attaches to that kind of location information.
Thank you. Now yield back, Mr. Chairman.
Thank you. The gentlewoman from California, Ms. Chu.
Thank you, Mr. Chair. For the panel, I'd like to ask this question. We trust law enforcement to use their own discretion in deciding whom to physically follow around for extended periods of time. Why can't law enforcement be trusted to exercise their discretion when engaging in similar tracking using GPS systems or cell phones? Isn't using electronic tracking just more efficient, or is there something fundamentally different about electronic tracking?
Thank you for the
Ms. Krimp?
Thank you for the question. There is something fundamentally different about electronic tracking. Physical tracking is by necessity limited by officer resources, and because that form of tracking requires the expenditure of tremendous resources, that itself acts on a check against abusive forms of that tracking. In contrast, electronic tracking is wholly concealed. Individuals don't know it's happening, but it can also be done in a very resource-efficient way, which means that legal protections against it are all the more important.
Mr. Blaze?
And if I might just add to that, the electronic tracking, unlike physical surveillance, follows us wherever we go, particularly cell phone-based electronic tracking. It follows us indoors into private spaces, in places where physical surveillance would be unable to track somebody, at least undetectably. So there's a technological distinction as well.
Okay.
Thank you for the question, Congresswoman Chu. I agree that a probable cause standard is appropriate for real-time GPS or other precise location data. Let me give you a couple reasons. One is that it is not event-based. Cell site information is derived from specific overt user activity, a call, the sending of a text message. And so that's generated in the network. The network has to know about that. The network can't not know about it any more than I can dial a phone number without, telling the phone company what number I want to call. It just is an innate part of the transaction. But the acquisition of precise location information may be done, as I indicated in my opening remarks, even when there is not an active communication in progress on the device. What's also, I think, significant here, even before anybody had cell phones, the Supreme Court indicated in a case in the early 1980s with respect to physical tracking devices that when a tracking device actually reveals the presence of something within a protected area that's not otherwise observable by the police, that can implicate a reasonable expectation of privacy. That's the Karo case, K-A-R-O. Now, there's an important distinction here, and that is between whether the item is merely in a protected area or whether the information about it reveals that it's there. So it's not just enough that something is in some area at the time that location data like cell site is acquired. But if the information is so precise as to place it inside a particular home, which is what happened with the physical GPS tracker in Karo, then yes, indeed, if you apply that same logic to cell phone GPS, it would follow that there's an expectation of privacy.
Yeah, in fact, I wanted to follow up by saying that the majority opinion in Jones found that a search occurred because law enforcement had committed a trespass by fixing this GPS tracking device to a private vehicle without a valid warrant. Does that mean there's less of a concern when location tracking is done without fixing a device, such as using cell phone location data? Ms. Crump?
No, I don't think there's any less of an expectation of privacy. The one opinion did focus on trespass, but 5 other justices focused on the nature of the intrusion of being tracked. To be sure, that case involved attachment of a GPS device, but I don't think, practically speaking, whether the technological method is attachment of a GPS device or a cell phone makes any difference. Although I'm always glad when there's agreement between the Department of Justice and the ACLU on a question, however we get there, I do think the distinction between whether the location data is generated by the network or an active intrusion into the phone is overly formalistic, and the more common sense approach is to focus on the privacy intrusion and what people's expectations are.
Okay. The gentlewoman's time has expired, and the chair yields himself 5 minutes to wrap up. Last year, the court handed down the Jones decision, and about the only thing the justices could agree upon was that there was a search that occurred. And then they were all over the map under what circumstances, a judicial review, and I don't want to talk about what type of specific review would be or what kind of warrant or 2703 device would be. But I would like to ask each of the witnesses whether they think it would be wise for Congress to try to set some markers on what needs to be done in advance, if anything, with various types of use of GPS equipment, or the topic of our first hearing on ECPA, largely to prevent a court decision from coming down years from now, which might reopen or place in jeopardy cases that already had been filed. And I would like to ask each of the 4 witnesses to answer that question. Meaning, do we need a bill, and what should the bill contain?
Thank you, Mr. Chairman. Just so I understand the question, is this directed to physical GPS, or do you still have in mind phone GPS?
Both.
As to physical GPS, such as that was at issue in the Jones case, it seems to me the Supreme Court has laid down a pretty clear marker, and there is already, at least in Federal Rule 41, there has been since 2006, a set of procedures for applying for and obtaining a warrant to install and use a physical tracking device. So it's not clear to me that there's a particular need for this committee to act in that area. Mr. Chairman, you mentioned, prior cases that may have been investigated or charged prior to a particular court decision. What's interesting is that in the roughly 15 months since Jones came down, that issue has come up across the country in various courts. And generally speaking, Jones has not resulted in the suppression of evidence for pre-Jones law enforcement conduct. The short answer is there's a good faith exception. And then to respond briefly to your question about phone location information, I would simply reiterate what I said earlier, that I think that would come at significant expense to important law enforcement equities. As to cell site location information, I don't think that it would be inappropriate at all to clarify, and in fact I've mentioned in my list of areas for the committee's further inquiry, the potential need to amend Rule 41 for prospective GPS acquisition on phones.
Mr. Modafferi.
Thank you. I would say that from my perspective as a detective, we do need clarification. We do need an act to clarify what the points that Mr. Eckermile made, because we are acting somewhat in the dark on certain areas. And as technology evolves, we need a law that can address things as it changes. but I wouldn't express, I'm not a lawyer, so I wouldn't get into the details of Mr. Eckenwell.
Ms. Crump?
The short answer to your question is yes, it is essential that Congress act. It took many years for the court to even reach the Jones decision. GPS tracking had been going on for a long time, and it only partially answered the question, and it's important that this body step in and clarify the law so that everyone understands what their rights are. Second, I think law enforcement and civil liberties organizations such as the ACLU at the least agree that the current system is unclear and in a state of chaos, with judges applying different standards to identical forms of tracking in different states, and that it's important that the law be uniform.
Mr. Blaze.
Thank you. I'm also not an attorney, so I'll answer from the technical perspective. Any legislation that attempts to distinguish between the revealing and intrusiveness of vehicular GPS, precise cellular geolocation, and cell site geolocation will be doomed to become increasingly meaningless as those technologies converge in their precision.
That concludes this hearing. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses and additional materials for the record. Gentleman from Virginia.
Consent that a law review article by Stephanie Pell, published in the Berkeley Technology Law Journal, be entered in the record.
Without objection, the hearing is adjourned.
It's very nice.